Mr. Casabon, your name? Well, if anybody I've had today deserves to go to jail, I hate to give you the bad news, it's you. Have you had a chance to review the report with him?
I have, Your Honor. There are no material additions or deletions we've added on the clients. I believe he can comply and look forward to.
Mr. Casabon, what can you tell me?
Well, Your Honor, when this all started about a month ago, I was having a problem with it. I had already do some self-checking, and this past month, honestly, I'm at 360. My life's changed, and I'm looking forward to.
Mom, come on up here a second. I hate to do this. He's old enough. He's going to be 40 years old pretty soon, right? I mean, you're 38, right?
Yes, sir.
You're going to die if you keep on this.
I'm experiencing health issues from using it in the past. They're kind of.
I don't want you to have to go into that. How you doing, ma'am?
Hello, good, thank you.
What's your name?
Deborah.
Deborah what? What can you tell me? You noticing a difference here?
Absolutely. I can tell you.
I scared her. I think I scared her.
Well, I think it scares me in here. It's just uncomfortable, but it's right. And we were never against, the consequences of the bad decisions when he was younger. And just, watch the struggle. And it's been a struggle for all of us to watch, but I can tell you since he's been out, it's been a year and a half almost. It's been different, it's been totally different. Now, little blips, friends are going away, and that's been a great thing. So getting rid of the old friends, the people that you think are okay. So now, since this, has it been?
The good news is this wasn't assaultive and it was not a drunk driving. It was loitering where drugs are present. I know he struggles with it. It's evident to me he's been struggling with it pretty much his whole life, going back to 05. I mean, it was just marijuana, then impaired 08, analogs 08. He's got larceny of buildings, retail frauds. He's got all these ugly convictions. He's got all these ugly convictions on here. And I'm sorry, I cut you off.
Well, no, I want to thank you.
You don't have to thank me. You would thank him because this makes parents get old. You're done with this. I'm telling you, I'll be your best friend if you stay clean. If you don't, I'm going to turn on you like you can't believe, because honestly and truly, I will go home tonight and wonder why I did not send you to jail.
I can show you. I can do this.
2 years probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you have to notify probation. No alcohol, no marijuana, no illegal drugs, none of them. Not to purchase, possess, or consume any. Submit to chemical testing on demand of probation. Submit to PBTs, ETGs, and chemical testing. Even though you're not drinking, it doesn't sound like, you're still going to go through 60 days on the sober link from today. You're to attend AA meetings at least 3 times per week. You're to obtain an AANA sponsor, attend all substance abuse treatment, attend the Victims Impact Panel, attend and complete the Armed Specialty Court Work Program, report to sobriety court status reviews with me every 2 weeks, obtain and maintain employment with proof provided. You don't have any health issues to prevent you from working on the work program, right? 100 fines, 100 costs. This is, again, I'm going to keep in mind, this is not a drunk driving or an assaulted. 100 fines, 100 costs, 75 victim charge, $50 justice assessment, 3 1/4. Screening fees, $60 for 385. Probation fees are $480. So your total's $865 plus $1245, 316 sobriety court fees, $1245. And I got to tell you, the court work program fees you're to clear all warrants within 30 days of sentencing. You're going to do 10 days on the court work program, and you're going to pay $35 for that, for a total of $350.
So you'll pay that when I go there, or that's just all of it?
That's all included.
Okay.
So Lisa, what did I said before that? I forgot what number I had.
I'm at $1,575 with the court work program.
100, 200, let me just double check that. Not that you wouldn't completely get it right. 385, 685, 745, 1145, 1225. Okay, I better do it again. I got 1575. Let me double check. 200.
That's what I said, $1,575.
Oh, okay. Thank you. All right, so 1575, I hate to do that, but if you violate 90 days, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer. Do you understand one another?
I do.
Stay with me.
I'm going to.
You seem like a nice kid, but you gotta stop the drugs. Okay? We're gonna help you.
I believe it.
Okay, ma'am, thanks for coming. You show up at sobriety court status reviews with him. That's fantastic. Of course. He's gonna be a different person. If he just stays with us, he's gonna be a different person. Payment.
Your Honor, my client's only got $100 today. He can stop that.
He does have 100, or
He's got $100.
pay 100 now, and then how much can you afford to pay?
50 a week work.
I'll tell you what, you do it however you want. I'll make 100 now, 100 bi-weekly, and I'll start that beginning June the 21st, okay?
Okay.
If you need more time, no problem, call the court, we'll go on Zoom, or you can come in here on or before the due date, 8:30, you'll meet with the probation. Sincerely wish you well. Good luck. Thank you. Thanks for coming, ma'am. Mr. Crawford, come on up here. Let's call in,
Mr. Bailey, join the breakout room.
Jessica O'Donnell. Derek Allen Makunovich, file number 24T642916. Ma'am, Ms. Lawler, you can come up to that microphone. That is a microphone again. Sir, your name?
Derek Allen, Makunovich.
Counsel?
Michael Crawford, representative.
We have two charges here. Failure to clear all warrants. They say he cleared, but then he got another charge that he didn't appear on, and he has a warrant outstanding. And two, failure to refrain from having contact with the victim. Ma'am, your name?
Danielle Lawler.
How is he going to proceed on these?
Your Honor, my client will plead guilty to both with the explanation.
Is that right, sir? Is that what you want to do?
Yes, Your Honor.
If you plead guilty here, I want you to understand you have 7 technical violations. Your probation could be revoked. You could be incarcerated on this. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights?
Yes, Your Honor.
And you could get the maximum. Do you understand that?
Yes, Your Honor.
Did you read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
Your name is O'Donnell? Do you understand everything here?
Yes.
You understand if you plead guilty, you're waiving your right to a hearing?
Yes.
Is the count one that you failed to clear all warrants? Again, you did as you were supposed to, but then allowed another one to occur. How do you plead to that?
Guilty.
Did you fail to clear all of your warrants? Well, let me put it to you this way. Did you acquire a warrant after you cleared them and then not clear that one?
Yes, I didn't have the money fully paid. What is paid for?
Sir.
Yes.
Is the count two that you failed to refrain from having contact with Danielle Lawler, being within 2 miles of her and her residence? How do you plead?
Guilty.
Did you come within 2 miles of her residence?
Yes, Your Honor.
Did you call her?
No.
Did you talk to her?
No.
Did you appear at her doorstep?
No.
Anybody force you to plead guilty?
No.
All right, so I'm gonna accept your plea to count one, failure to clear all warrants, and 2, violation of the no contact, at least the order not to be within 2 miles of her. What happened? Can you tell me, Ms. Warren, or Ms. Lawler?
Yeah, so I was made aware that there would be a play date between my daughter and one of her school friends who lives 3 to 4 blocks away from my house. Play date has happened there before, however, it was not Derek who took her, it was Lori, which was fine.
Who's Lori?
His wife.
Okay,
And there was no incidents that day. The date went fine. He wasn't present. Ellie confirmed that he wasn't present. I found out a few days before this violation occurred that there would be another play date. I assumed it would go just the way it went before, where Lori would be the one taking her there and he would not be present. He did send me a message for that first play date, confirming that he knew he should not be there because of the no contact order. So for the second play date, I assumed it would be the same. However, when I went to pick up Ellie that night at 6 p.m., I did witness them saying, so we drop off at the Trenton Police Department when she comes back to me. I pulled up to the police station approximately 10 minutes to 6, and they were sitting in the back of
who's they?
Ellie, Derek, and Dory. In the back of the car, the hatch up, eating ice cream from Custard Corner. And that's something he said that he's been wanting to do, is get Custard Corner. When Ellie got in the car with me, she talked to me about the play date, and I did confirm that Derek was present the entire day at the friend's house. I verified where the friend's house was again with her, just to make sure there was no mistake. He was present for the play date and then stayed in the area to go to Custer Corner until drop off.
Alright. So he didn't have any direct contact with you. He took his daughter to a location that's less than 2 miles away. Did you say a few blocks, right?
Yes.
But he didn't call you, other than that first time, text you to say, hey, I'm going there on a play date, it's a violation of the court's order.
No, he stated that he would not be there because he knew he couldn't
Right.
be that close.
Why are you doing that if you know it's a violation of the court's order?
That was a different location, play date, that I knew. I wasn't aware until we got this play date, how close we are, and I should have left.
Your Honor, again, these are two different incidents.
I know.
The one that he said he thought would be a violation, he believed that proximity would have been a violation. The issue with this last one, he was taking his child to a birthday party, if I understand it. His wife was driving. They didn't think he was within this area. So he thought it was okay for him to go. So he went, had a birthday party, he left. So again, he understands that technically, upon being aware of the proximity, it is a violation. He wants to take responsibility for
You know how
that.
to use Google Maps, right?
My wife, I should have, as soon as we got
So
there.
all you have to do is put in her address where she lives and put in the address where you're going and figure out how far it is.
That's what we did. Now we have a radius bubble, so I know exactly for sure.
And Your Honor, we would like to draw to the court's attention, again, hoping that my client isn't incarcerated, he's gainfully employed. Your Honor, I want the court to reconsider how it fashions this particular order, because effectively, he can't really parent his child. He can't take his child to school because of that proximity to 2 miles. He can't take her to dance class or any activities. He effectively will have no parenting time. And as you can see, based on both these violations, he's not actually trying to have contact with the victim or anything. He's trying to be a parent, a father to his child. So if there's a way we fashion this moving forward, the court could forgive him and understand his circumstance, it would help him out a lot. And the other violation, Your Honor,
Something bothered me here when I sentenced him, I can tell you that. Go ahead, I'm sorry.
the other violation, Your Honor, my client cleared all the warrants as he was supposed to his last order by the court. This additional matter came up. My client submits, and I have personal understanding of this. He was led to believe that he had paid everything off on the ticket down to 36th District Court. Sometimes the court, because of its busyness and its huge administration, can get things a little confusing. There could be a miscommunication, even within his own ranks. He walked out and thought he had paid, but then he came to be aware there was this small balance he still had to pay. So that popped up new to him after he thought he had cleared everything and was in compliance. As soon as he was aware that, okay, he owed another $100, he went down there and paid it, Your Honor.
Judge, if I could, on that warrant, that 36th District Court warrant, he did clear it on September 19th originally. He was then scheduled for a hearing as a pretrial hearing, like most cases would be. He didn't show for that hearing. That's why the warrant was then reissued. Also, he owes a balance of $290, so it wasn't a small balance that was owed on that. That has since been cleared at this point. He does owe a balance. They've given him till July to pay that balance as of today.
So it's been cleared, Your Honor.
How far do you live, Vic?
I live in Suffolk.
I'm just asking miles away.
I think 10, 15 miles, I'm not sure exactly.
Who has custody primarily, you? So I want you to understand something. When I put these protections in place, I'm doing it for the benefit of the victim, okay? But the intent behind it is that he not be allowed to call you, text you, drive by your house, be some wise guy like that. It's not that he not be able to bring his daughter to a party that happens to be within 2 miles of your residence or bring her other places. I want you to understand that. And again, you've not been a model probationer. I don't know what's going on with you, Mr. Makunovich. You got 7 violations since August. We're not gonna get along good if you come back in front of me again. I'm promising you that. I hope you do.
Yes.
So I'm just telling you, that's my intent. These are not the biggest violations I've ever seen. So I'm not gonna do anything. I'm accepting his pleas. I'm gonna not require any additional costs, even though I could certainly justify
Judge,
that.
could I just make one comment though, just because when the victim Danielle issued the police report, she said that this incident would happen on April 23rd of 2025. The day after that, April 24th of 2025, Derek emailed me asking for the court's, Judge McNally's order, stated he needed them because he wanted to file a police report against Danielle, the victim on this case, because he believed that she drove past his house, and he believes that she broke that no contact order because he believes she drove past his house. I stated to him that the no contact order is not for him, is for him to not be near her, and again, could he necessarily prove that she drove past his house or not? So again, I do believe that Derek is very aware of the no contact, and he's very aware he's not supposed to be in 2 miles. I know it's difficult being that they share a child, but these are the consequences of Derek's actions.
You know, those are totally different circumstances.
Well,
She can't lie. She misunderstood what the protective order did, but what he was even alleging was that she came too close to him. What we're talking about is he was trying to parent his child. So
Again, I think the timing of it though, the day after the incident happened, I think he was very much aware that he broke the no contact order on that.
I don't think there's any question that based on what I've heard, that he knew it was violating the no contact provision. I mean, maybe not. I'm not gonna go into this. And when I say violated the no contact, he violated the zone within which he could drive. I'm not condoning his conduct. I'm not condoning your conduct at all. You don't get to violate judge's orders. That being said, the intent of the order was not so that you couldn't drive your child or be at your child's play date, so to speak, that's located within 2 miles of the victim's residence. That was never the intent. So I'm going to go ahead, I'm not going to impose costs, probation order modified. You're not to have direct or indirect contact with the victim. Requirement that he not be within 2 miles of the victim or residence or place of employment is deleted. Now, I want you to listen to me. Don't start puffing your chest over this one. I'm giving you a break.
Thank you, Your Honor.
I'm telling you, don't go near that lady. If I find out you're driving down the street, and by the way, when you start making comments about what the judge's order should be or not be, or is, I don't tell victims they can't have contact. If she called you on the phone, the fact that you could pick up the phone and talk to her, that's a violation by you, not her. Okay?
Okay.
Stay away from her. Except as I've got in this order. I wrote down here, no contact with Daniel Lauer except in conjunction with circuit court. Can't read my own writing here. I think I wrote circuit court procedure, I don't know. But the point is, you two, you, Mr. Vukunovich, something bothered me here. I mean, something bothered me. So I'm gonna let this go, but don't get to thinking that I'm gonna order her not to have contact with you, and don't get to thinking that, don't read any more into this as it is. If there's a violation of no contact provision, you're going to jail. Okay?
Okay.
That's it. Have a nice day. Thank you very much. Good luck. Thank you. Oh, boy. I know, it's taking some time. This is the problem. Philip Kendrick. Philip Dwayne Kendrick II, 25W838-318A and B. I need your lawyer.
Right to the podium here.
I need his lawyer.
Mr. Crawford's in a breakout room. The defendant.
Okay, let's do that. Philip Kendrick, 25W838-318A and B and C. Your name, sir?
Philip Dwayne Kendrick II.
Counsel?
Michael Crawford representing Mr. Kendrick.
He's going to plead guilty to file a lesser count allowing a licensed driver to drive. He's going to plead to impeding traffic. They are going to dismiss the driving on a suspended, the open intox, and the expired plate. True?
True, Your Honor.
Is that what you want to do, sir?
Yes, Your Honor.
If you plead to allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail. Costs are all those. If you plead to impeding, that's 0 points. Do you understand that?
Yes, Your
Did you
Honor.
sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes,
To
Your
the
Honor.
charge of allowing an unlicensed driver to drive, how do you plead?
Guilty.
To the charge of impeding traffic, responsible or not responsible?
Responsible.
Were you in control of a 2011 Chevy that was being operated on West near Meyer Drive in Woodhaven, March 31 at 25 at 8:41 PM?
Yes, Your
Did you
Honor.
allow somebody to drive that was unlicensed, and was that you?
Yes, Your
Are
Honor.
you on probation or parole?
No, Your Honor.
Anybody force you to plead guilty?
No.
Please accept it to allow an unlicensed driver to drive. Please accept it to impeding traffic. That is on file C, count 3. And the suspend, count 1, and open intox, count 2 are dismissed, as well as the original charge of expired plate. Counsel, you ready for sentence?
Yes, Your Honor.
Anything? He's driving on a revoked. Why?
My client was being a little silly this particular time.
Yes, Your Honor.
He was trying to impress a young lady. His sister let him use her Camaro, yellow Camaro, nice. The young lady just tried to take her out for a date. Things went out of control. He knows that was a bad decision, wholly irresponsible. Otherwise, he Ubers around like he's supposed to ever since he's been in this situation. Expensive, but pretty lady got him in bad decisions.
So we're gonna blame the pretty lady.
Well, no, he take responsibility. That was just the outside catalyst that caused him to make a bad decision.
No.
What do you want to say, Mr. Kendrick?
It's on me.
What do you want to say? Anything?
No, I just
You
want
work?
to say
You
that I take 100% responsibility. I do work. I'm operations manager for a logistics company, Traffic Tech.
You got a good job. You're well-spoken.
Yeah, but just laid off temporarily right now due to the tariff situation, but I'll be back probably in a couple weeks on my next assignment.
You can't drive on a revoked.
I know that, Your Honor. I should not have done it.
100 fines, 160 costs, 75 victims' rights, $50 justice assessment, 385 plus 40 in attorney fees for a total of 425 or 90 days. That's on that one. 165 on the impeding traffic. Can you pay all that
Well,
today?
my client can't pay all of that, so what he can pay is $400 today.
Okay, he's gonna pay hang on, he's gonna pay the impeding now, that's 165. And then he's gonna pay 235 toward the 425, and I'll just give him until June 21st. Is that good to pay the rest?
Yes,
You'd have to pay another 190. Can you do that?
yes, I
By
can do
June the
that.
23rd?
Yes,
I'll make it the 27th,
okay.
okay? We don't know how to take care of those. Don't come back in here, okay, please? Thank you. On revoke, thank you.
Good morning, Your Honor. Kimberly Downs, P44711. I'm appearing on behalf of Mr. Luckington.
Your name, sir? Are you here on this?
I am here on Inch, but I can go.
I need you to pull this file. All right, so defendant hasn't been here.
Yes, Your Honor.
We have multiple counts. He has 2 prior technical violations. He absconded. I have 6 counts. How's he going to proceed on these?
Your Honor, as I had indicated to you off the record, I was trying to get some more information as to the status of this file.
Well, the status is that he's blown us off for 3 years. That's the status. I sentenced him May the 12th of 22. I don't know what else to tell you.
Well,
You can look at the probation violations. He's got 6 of them. They think he didn't attend his probation visit on October 13, that he didn't attend the court work program on October 5 of 22, that he didn't provide proof of completing 4 hours community service by October 10 of 22. He didn't even provide verification of attending and completing outpatient treatment. That he failed to refrain from consuming alcohol and controlled substance, testing positive for marijuana and alcohol back at a chemical test back on September 13 of 22. I don't know what else to tell you. I mean, you can look at the file. He pled to impaired.
Your Honor, may I address you now?
No, you look at the file. I can only do this in one way. I don't do cops, please.
Okay,
He's got a big problem with me.
all right.
He's blown off the court for 3 years, and I don't appreciate it. So
We have,
I know, he was running the Pentagon. I don't know what to tell you, seriously. I don't want to hear these excuses. He knows that I know if I told him I'd give him $5,000, he'd have been here 3 years ago.
give me a chance to,
Yeah, take your time, but I don't get it. I just don't get some of these guys. I really don't. They just Guys and gals think they don't have to show up for 3 years and then come in and pretend like it didn't happen.
He's not a bad.
Oh, I'm sure he's not. None of them are.
He's not.
Anybody who ignores a court for 3 years is about as respectful as, that's the way I feel about it. You can come back and prove to me I've been thinking wrong for 60 years. William Michael James, 23B726981. Sir? All right, so have you had a chance to review this file?
I did, Your Honor.
What is he going to do? Is he going to plead or does he want a hearing on these 6 counts?
No. He will plead.
So, sir, if you plead guilty here, I want you to understand your probation could be revoked and you could be incarcerated for 93 days. Do you understand that? And did he sign an advice of rights form today?
He did not, Your Honor.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes.
If you plead guilty, you're waiving your right to a contested hearing, you're waiving your right to a hearing of any kind, and you could be incarcerated, as I said. And again, you have 2 priors, technical violations, it says. But given that you have absconded, you could get the maximum. Do you understand that?
Yes.
Any questions before we go on?
Your Honor, best with Judge Hudson.
Okay. Any questions before we go on?
He's back on Zoom. Mason. He's in custody.
No questions, Your
All
Honor.
right, as to count 1 that you failed to attend your scheduled visit on October 13 with probation of 22, how do you plead?
Yes.
You failed to attend your probation visit on that date.
Yes.
Count 2 that you failed to attend the court work program on October 5 of 22, how do you plead?
Yes.
You failed to attend on that day.
I showed up, but I had on shorts and I forgot that you can wear shorts and sent me on.
Count 3 that you failed to provide proof for completing 4 hours of community service by October 10 of 22, how do you plead?
Yes.
Did you fail to do that?
That's community service. That was my last day. I had community service, but I forgot I couldn't wear shorts.
You did 3 days.
Community service is different than court work. You would have set up your own community service.
I don't think, we were talking about this, Your Honor. I don't think he understands the court work program.
It's not considered community service. It is community service, but it's supervised court work. So I ordered you to do 4 more hours of community service at some point, and I'm just asking you, did you complete the 4 hours of community service by the due date of October the 10th of 22?
He completed 3 days.
No, that's a court work program. I sanctioned him at one point in August 31 of 22 in order to complete 4 hours of community service by October 10. So the charge is that he failed to provide proof of completing that by October 10. So how do you plead to that? Why are you confused?
Yeah, not guilty.
Did you fail to provide proof of completing community service hours that you were due to do?
I had 4 more left. I had 4 more hours left. The day sent me on. That was my last day of community service.
That's the court work program. I don't know how many times I gotta tell you that. When we're supervising, when you're showing up at this building, that's the court work program. That's where it's a little bit more stringent. I allowed you to do community service where you could go fold clothes somewhere at the Salvation Army or do something else by October 10th.
I can't do it.
He did not. That's the court work program. Are you listening to me?
But he said that they sent you home from the court work program.
That's not community service.
Oh, my bad.
You could have done community service at Salvation Army, St. Vincent de Paul, a church, Habitat for Humanity, an animal shelter. You could have done it wherever you wanted. You could have done it.
Oh, I had it confused. I'm sorry.
Oh, yeah, that's all right.
Yeah.
But so I'm going to ask you again, did you fail to complete that by October 10 of 22? You didn't do it, right?
Right.
Count 5. That you failed to refrain from consuming alcohol, testing positive on September 13 of 22 for both alcohol, that's on count 5. How do you plead to that?
Guilty.
And count 6, marijuana. How do you plead to that?
Guilty.
Did you consume alcohol and drugs, marijuana within the 3 days before September 13?
Yeah.
Anybody force you to plead guilty? Pleas are accepted to those charges. You got 6 counts. I can't wait to hear what the explanation is. I have a feeling I'm not gonna like it because it's gonna be some, he didn't have a ride or he forgot or.
Your Honor, I would just very much appreciate it if you at least let me explain something.
Oh, no, you explain all of it. Take your time, have at it.
First of all, that was in 2022. This is 2025. Mr. Lucky's in a completely different position in terms of where he is with this case. He wants to take care of all of this and meet his responsibilities under this case. Him not showing up, he moved to Ohio.
Did he get permission to leave the state?
I had nowhere to live in Detroit.
I'm just asking you, did you get permission from anybody to leave the state?
You said I can go to work, because I work now. You said I can,
I didn't say you could live there though, did I?
No, I ain't had no choice.
I said you can leave state for employment, but go ahead. So he violated probation in that aspect too, but go ahead.
Okay, so, he was in Ohio, and because he had, this is based on the OWI charge, his license was revoked, so he didn't have transportation up here. Now he does,
How many drunk drivings does he have?
just one.
They didn't revoke him there.
No,
They just,
never had. No, I was trying to get my license when I ended up catching I was just paying my tickets off. When I ended up catching
okay, go ahead, counsel.
Okay, so anyway, now he has access to transportation through his brother. Secondly, Your Honor, again, he moved to Ohio,
Whereabouts in Ohio?
Toledo.
This was a second drunk driving, right? Or at least he didn't appear to see. He had one in 15.
I thought this was the only one, Your Honor.
Well, maybe he still has that warrant out. Let me double check out of Dearborn.
I had no warrants.
Go ahead, counsel, I'm listening to you.
Okay. So anyway, because he was in Ohio, that prevented him from coming. He didn't have to,
Where's he live in Ohio?
this is what I have to offer.
Where's he live in Ohio?
He's living in Toledo.
Come on.
So now through his brother, which he didn't have that transportation before, he has transportation now. He can get to his scheduled appointments. He can get to whatever programs and whatever he has to do. He's also able to pay all of his probation fees. And I would just ask Your Honor to consider all that. Like I said, he's not the same guy that he was in 2000.
Well, you're not giving me any reason to tell me he's changed, other than the fact that he moved to Ohio and couldn't get here from Toledo, which is
Well,
only
what
4.
has changed, I should say, not necessarily, I can't speak about him, but what has changed is that he has transportation. He has access to some.
Where does he work?
He was working at the Chrysler plant and then got laid off.
When did he get, what Chrysler plant?
Toledo.
When did you get laid off?
January,
How long were you working there?
2017.
Did somebody call, Beth on this?
I'm not sure if John did, Judge, but I'll call her now.
Well, he did say she was in Judge Husson's. I don't know if she still is. Can you tell by looking out there, Lisa, is she still in Judge Husson's?
I can't see her courtroom, Judge.
Okay. All right, go ahead.
So anyway, for all of these reasons, I'm asking you to give my client another
You
chance.
know, I just don't,
And,
you know, I'm telling you the way, to me, there's no stay of the probationary period. He's been gone for 3 years. I really, as far as I'm concerned, I lose jurisdiction after today. I mean, there's nothing I can do when they do this. That's why it's upsetting.
I understand.
You know, he doesn't show up here. We know what happened. He tested positive. He got scared or unconcerned. He didn't do anything. Had 2 violations within the first 3 months.
But that's exactly what happened, Your Honor. He got scared. When he moved to Ohio and wasn't making his probation meetings, he felt that he was already in violation.
Well, yeah,
And I know the thing to do, or what the thing he should have done, was to call someone to tell them what his situation was. But we deal with real people. And,
Do you have kids? You married?
I got 3 kids, and that was a whole accident.
Where were your kids at?
At school, right now.
No. Where were they in 22, 23?
In 22, we was all together, we was all living together after the accident.
Slow down.
Yeah.
How old are your kids?
I got a 19-year-old now, a 16-year-old, and a
Did
12-year-old.
they all move to Toledo with you?
No,
They stayed in Detroit?
yes. Me and my lady split up after the accident in one car. It really took.
he had an accident, sure.
That's what I'm talking about. It really messed up my whole life. I had the phone, my old number with the all your contacts in it. She broke the phone. I couldn't get in the iCloud.
Just to put some context to this, on this OWI charge, there was a truck that hit him. And it kind of dominoed from there. And that's what he's trying to explain.
How old are you?
40.
You got laid off from Chrysler, Jeep plant in what month? January?
Yeah, yes.
Is that a permanent layoff or is that?
Yeah, because I didn't take the full time. I had turned it down, and I got pushed it back to the back. So now I'm on like what do they call it, TS or like a train, like a TPT. So I might, they might call me for the summer. I might.
Oh, you're a temporary employee?
Yeah.
Who do you live with now?
Homegirl,
Pardon?
one of my friends. She's my friend. I would say my girlfriend.
Well, that's all right. I don't need to get detailed. I just wondered where you're traveling about. You left your brothers then, right?
Can I leave my brothers?
Yeah.
No, I don't stay with my brother. He just.
I thought you said it did, maybe I misunderstood you. Did you tell me or did you not tell me that you went to live with your brother in Ohio? Did I misunderstand?
In Ohio. I stayed with my uncle in Ohio. When I left my family in 2022, I went to Ohio and stayed out there in Ohio. Was going to work
With who?
out there.
With who?
My homegirl.
Your girlfriend?
I said my girlfriend.
What's your name?
Elizabeth Washbation.
Can you give me any good news on this one?
I think the only bit of good news that I can give to you on Mr. Lucky is he did complete his victims impact panel. Other than that, unfortunately, it was kind of complete abscondment after he had missed his appointment October 13th. And even the 4 hours of community service was part of penalty from a prior violation. He didn't even complete those 4 hours of community service. I wish I had better things to say, but he just basically up and left and we didn't hear from him again.
And like I said, Your Honor, that's because of transportation issue. It is because he should have called. He should have let the probation officer know. However, he didn't do that. And he's in this situation now.
I mean, he just ignored us here. I'm looking at this. It's like, seriously?
But you know what people do, Your Honor? When they think they're facing penalties in jail, thinking that they're
I get it. I just still,
hide.
yeah, I get it.
I can appreciate transportation issues, but he was reporting by Zoom, Your Honor.
And not only that, he didn't live in Cleveland. He's living in Toledo. I mean, if I'm going to say somebody that I'm going to excuse somebody for not having transportation that lives in Toledo, I've got to pretty much excuse anybody who lives north of, I don't know, north of 12-mile road practice. And then I'm just not prepared to do. We could have gotten here. He knows he could have gotten here.
He didn't have anybody to help him at that time. He's got his brother to help him now. And that was the problem. It was a problem getting here. It was a problem with having someone bring him here. And who he had is his brother.
You know, you're on the same page. I mean, I remember a justice writing something about, well, people don't have to get rides. Let's do it on Zoom. All I know, I don't say this very often. All I know is that anybody that comes here in this courthouse, there's only one of three things. They either live here, they drove here to commit the crime, right? or they got a ride here. That's the only three things anybody could possibly come in front of me. They either here, they here, or they got a ride here. So I don't know what's so difficult about asking people that got a ride or drove here to get a ride here to pay the piper.
Right.
You know what I mean? So I'm trying to be understanding. I'm telling you, I'm not a fan of this. I never have been, and I never will be. I will do the best I can for them. How much do you have here, Lisa, in fees does he owe?
$884.
He will be able to pay that right away, Judge.
Does he have any credit coming other than the
The
one?
only credit I can say is we had scheduled for the work program. He was a no-show a few times. He wore shorts once, but he did complete at least one day of the work program, which was August 3rd. So I would say he's got a day of credit for that, Your Honor.
Doesn't look, it looks like he had a warrant out of someplace in 2015, out of the Dearborn District for OWI. I don't see any disposition on that, either on his traffic record or on the criminal history. I don't know what happened with that.
Your Honor, I can't say this for certain, but I don't believe he was charged. This is because it's my understanding, this is his only charge.
Well, they issued a warrant for him on an OWI at one point, failure to appear in court back in 15.
I do have the screening assessment obviously done at the time of his plea, Your Honor. 2012 out of 19th, he had failure to appear on drug and license suspended. 2015 out of Dearborn 19th for OWI and drug and license suspended. He also had 2019 out of 34th, but those were for civil infractions of speeding and no.
I'm not going to take that into account. I was just mentioning that. If there's no evidence of a conviction, there's no evidence of a conviction. Probation is revoked. You're to pay costs of $950 and serve 93 days jail, credit 2, for a total of 91. If you pay costs of $950, I will suspend 72 of the 91, requiring you to only serve 19. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. So you pay that money now, you'll be out in 19 days with credit for time served. No.
I have one last issue, Judge. You're gonna be sick of me. But there was a court date scheduled for May, and he didn't get a notice and I didn't get a notice. I spoke to the clerk, Lisa. I submitted an appearance by internet. She said, no, the court never got an appearance from me. And the notice was sent to Mr. Lucky's former address on Braille in Detroit and not to his current address.
Well, how are we supposed to know?
I don't know. I did my part.
Well,
At least I thought.
but we don't have an appearance in the file until the one you filed on May the 15th.
Exactly, that's what she told me. And I don't know how that happened.
So, I don't
Because
know.
I didn't, the appearance I sent in, I didn't send it in to Lisa. I didn't write down who or
So what are you asking?
Sorry?
I don't know what you're asking me.
Oh, if you would reinstate the bond. And that was,
There was a third-party bond posted, Judge.
Yeah.
and that would help pay.
I'm not gonna, I'll tell you what, if you want to address this when he's out of jail, I don't have a problem. I don't even have a problem with you addressing it by Zoom. But there's too much for me to digest here. When people don't show up, I'm not gonna apologize. I don't like it. And you play,
Can we get the bond? Can we at least apply?
I heard what you said. I understand, but he hasn't shown up for 3 years. I mean, what is this?
Okay.
What bond are you talking about? The one that-
Judge, I can explain it. He posted a bond, so I set a court date. He did not appear because we had an old address. She states that she filed an appearance, but I never received it.
Is this a bond that he posted online on or about April 22nd?
Yes.
Yeah.
Yes. So then when I heard from her questioning why she never got a date, she sent me a new appearance and I reset the court date.
I don't have a problem with reinstating the bond, but he's gonna have to pay whatever else he paid because that's in the name of the third-party poster. So the third-party poster can come in here, we'll refund the money to the third-party poster.
Okay,
Okay, I'll do that. I can
Thank
see
you.
that at least he did that.
thank you.
But he's gonna have to pay his money today without the bond. And then he'll just have to serve those days that I gave him, which is after he pays the bond 19. Or pays the fines and costs 19.
All right.
Stop doing this. Good luck, have a seat, thank you. People against,
Mr. Lucky.
Tangeray,
Thank you,
I
sir.
want, thank you very much. What did Mr. Boulahanas have, Lisa? I saw him poke his head in, I didn't know.
He's with the prosecutor. He's got a new case.
Okay. Don't let me forget, I want to get these sentencing stuff.
Okay.
Tell him half an hour. We'll call him.
All right.
I don't know whether I want to start off with Mr. Blisman or not. Thomas Robert Blisman, 25W706462 FD.
Good morning, Your Honor. Mr. Shepard, can we have my client approaches?
So this is not going to be an easy one. Your name, sir?
Thomas Wilson.
All right, so he's done well on the bond phase. I took his plea to OWI 2 and to drive while suspend 1. And that was on April the 22nd. So I want to read the plea agreement into the record again, if I can, if you'll give me a minute. And everybody sign this, and here's what it says. Defendant will enter pleas to OWI 2nd and an added count of driving on a suspended. Sentence recommendation of 60 to 90 days jail is determined by the judge with work release if eligible and available. This jail condition may be waived at the discretion of the court if the defendant completes a specialty court program pursuant to statute. The OWI 3 charges will be dismissed at sentencing, provided the terms of the agreement are satisfied. Sentence of agreement of 2 years probation with sobriety, drug veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination of the probation. Any SCAO approved sobriety or specialty court will be acceptable. The 33rd District Court has an acceptable program. That's nice of them to tell me that. In addition, all the terms set by the court, costs of prosecution of a minimum of $500 or more is determined in alcohol, drug screening, treatment, full restitution for any out-of-pocket costs for damages or harm incurred because of the offense on or before sentencing, if applicable. So I want to make sure, do we have the vehicle owner here that should have been notified? If you just give me 1 second here. We did send a letter to Gary Ennis Jr. on April the 22nd and also to Jason Glenn. This was a parked car, right? Is this not a parked car or am I confusing this one? I'm just asking you. Can you tell me, Mr. Shemke?
Car was parked, I believe.
Yeah, I'm just curious as to why they notified 2 separate owners. Let me just double check something. Yeah, Unit 2, that's you. Was traveling northbound. I'm sorry, Unit 1 struck, that's you. Unit 3, which was parked on the street. I don't know why they, at any rate, I don't need to deal with that. I'm concerned he's got 3 priors. Granted, none of them have happened in the last 24 years. I'll give him that, 25 years, but still it's a 4th offense. I'll listen to anything you have to say, and we'll go from there.
Yes, Your Honor, in the circumstance, I'd like to reflect that he has done extremely well on bond. He has a strong family support system. He has remained gainfully employed. Judge, he had used poor judgment. He was trying to assist a friend and he found himself in this predicament. But I will say, as far as the client goes, any instructions that I give him, he's always been able to follow without any sort of issue. He's already been in treatment. Any sort of request or order that's been put in place by the court, my client has not hesitated to comply with 100% accuracy. It's because of that, Judge, and how well he's done on bond and the strides he's made with his life in the past few years, besides having this notation, I'd ask for jail to be waived at this time, honestly, to be considered if there were to be a violation, but he's very eager to demonstrate full compliance with the sobriety court. He appears timely, very respectful, and I think that he's going to demonstrate an outstanding effort in the program, Your Honor.
Anything you'd like to say?
Yes, I know I made a bad mistake, bad judgment, but looking forward, I want to just, get this behind me and I'll do whatever I have to do to make things, right.
I don't know if I've ever had a fourth offender that I didn't send to jail, to be honest with you. I'm a drunk driver. I can't think of one. It's possible, but I don't know that I have. 2 years probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume those. You're not to go to any place where alcohol is sold or dispensed. You're to submit to chemical testing, PBTs, and ETGs when probation tells you to, when you know how often you have to test. You're to submit the PBTs, ETGs, and chemical testing on demand of probation. Like I said, you're to complete 60 days more on the ShoulderLink device from this date. But we will get that turned around. It'll be now covered by our grant. You're to attend 12-step meetings 3 times per week and provide written proof of attendance. You're to obtain an AANA 12-step sponsor. You're to attend all substance abuse treatment at an approved facility and provide written proof. You're to attend the Victims Impact Panel. You're to attend and complete the Armed Specialty Program. You're to report to sobriety court status review hearings with me every 2 weeks. You're to obtain and maintain employment and provide us with proof. Now, I'm going to talk about the fines. There was an agreement of $500, so I'm going to honor that. 200 fines, 500 costs, 75 victims' rights fee, $50 justice assessment, 8 1/4. Screening fee is $60 for 885. Probation fees are $480, bringing your total to $1365. Sobriety court probation fees, sobriety court fees are $360, bringing your total to $1,725. I'm coming back to that. You do have to pay, and I feel badly about this, but there's only so much I can do. Cost of recovery on this case is $150. So your total's $1,875. Now, I don't know what to do with you, Mr. Blisman. I don't usually come out here and say that. I don't. I mean, there's times I don't know exactly which direction I want to go, but all right. I'm going to do this one a little different. I'm going to give you 200 fines. Cost $500, that's per the agreement. $75 victims' rights fee, $50 justice assessment fee. $60 screening fee, $480 in probation fees, $360 in sobriety court fees. There's cost of recovery of $150. I'm going to order that you serve 90 days jail, and that will be deferred. You're going to serve I'm giving you credit for 1 day served. You're to serve 6 days on the court work program and pay $210 for that. That's your first 6 plus the 1 day credit. You're going to complete 4 days of community service. I'm going to give you all the way until September 1st to complete that. That's 32 hours. We're going to have review hearing dates. And by the way, your total now fines and costs, including the court work program fees, with the $500 minimum cost, I don't know why they're putting that in there, but I'm going to honor it. It's $2,085, and I feel terrible about that, but I can't really do any better. I mean, these are all fees that are associated with the program. So it's 11 days jail now. Credit 1. Serve 6 on the court work, 4 days community service. I'm giving you until September 1 to complete your community service. 79 days are deferred. You're to appear for a review hearing date. Lisa, I want you to give them a review hearing date every 4 months for me to determine if the defendant should have to serve the jail then. And here's the bottom line. You do everything. You cross all your T's. You dot all your I's. I'm not going to end up sending you to jail on this, and that's significant. I know that the other ones are old. but you still have 4 of these. Now, the last one was 20 years ago or so, whatever I said, but I'm gonna do that. But, I mean, I'm giving you credit. You're doing well so far. I'm glad to see that they're not hamstringing me on these probation sobriety court cases. You know, some could criticize. That's okay. But if you violate 365, and I'm telling you, I will give you the 365 days if you don't make it through the program. But I hope your goal here is not to make it through the program, it's to gain lifelong sobriety. Restitution, if any, will be handled through civil litigation. None of the names I mentioned are here, correct, Lisa?
I have a Motorola that just popped in that I can't identify.
Well, let's bring them in or her in, whoever it is, and I'll ask them. How's that? So I'm gonna do this for you, Mr. Plisman. Not that you don't deserve it. But it has been a long time, and we do make mistakes, and you've shown that you're, to me at least, that you're accepting responsibility, you're remorseful, you've done what we've asked you to do. So I'm gonna be more reasonable here. More reasonable at least than I should be. Let's put it that way. Motorola, can you tell us your name, please? You have to show up with your name on there, please. What's your name? Motorola Moto G Power 55G 2023. What's your name? Start your video and tell me your name, please. Motorola G. Moto, if you better call, I don't know your name, sir. And you have to use, or ma'am, what's your name?
Judge, that's Stephen Bailey.
Okay, good
Yeah,
enough.
we're good.
So that's what we're doing. Can you pay all this today or do you need time?
Payment plan.
How much do you have today?
Judge, I think there's a count too also.
Yeah, I know. I gotta go on to that. You pay $1,000 on this. And then the balance, I'm just gonna let you pay at the rate of $100 bi-weekly. Can you do that?
Yes, sir.
Pay that $100 bi-weekly. We'll start that. I'll give you some little bit of leeway time. 6/13/20. Is the 27th a Friday, right, Lisa? Of June?
Yes.
Okay, so that's what we'll do on that one. I don't really have a register. Give me the other file. I'm gonna go light on, I just need another page of a register for count 2, like a first page. I'm just gonna fine you on that. I'll go light. 50 fines, 50 costs, 75 victim rights fee, $50 justice assessment, 2 1/4, or 90 days, okay? Okay, sir? So here's what I'll do. Do you think that you can pay this, say before your first payment's due on the drunk driving?
Yeah, I pay this.
I'll tell you what, let's just do this. I'm gonna make it easier. On the drunk driving charge, we're only going to have you pay $775 now, okay? So that'll be $775 on that case, and you're also gonna pay the suspense, so you pay both. Pay $775, you pay the suspense charge of $225, and then you pay $775 on the drunk driving, OWI 2, and, then you just stick with that payment plan of $100 bi-weekly starting June 27th. Again, no problem if you need more time. I'll be glad to give it to you. You'll meet with probation. They might not need to talk to you, but since we had status reviews this morning, okay? I wish you well. Stay with me on this, please. Good luck.
Did you say review dates every 4 months?
Correct, and I'm gonna let you just set those up.
Okay.
Yeah. Okay, thanks. Silvana, Barry, you're all set. 25W8388569. Does he have a lawyer?
I'm sorry?
Does this defendant have a lawyer?
Yes, Your Honor. Christopher Shenke appearing on behalf of Attorney Record Christopher Lane. I do have the authority to stand in.
Did he call here and ask for a lawyer to stand in?
No, Mr. Lane, he's a close friend of mine. I saw his name on there. I called him and I said I'd be happy to assist. So if he was happy to zoom in. I thought I was just trying to help.
Okay, good enough. To the charge, and you're authorized in that plea to the charge of impeding traffic,
I am
responsible or not responsible?
responsible, Judge.
Plea is accepted. Original charge dismissed. I see they need a week to pay. 180 is the total, and I'm gonna have them paid by June, we'll just give it till June the 10th, okay?
Thank you,
June the
Judge.
10th, thanks. Darnell Clark. Darnell Benjamin Clark, 25W87-686A.
Good morning, Your Honor. Mr. Sheffield, can I get my client approaches stance if I can get one?
How you doing, Mr. Clark? Your name?
Darnell Clark.
All right, your client pled guilty to the charge of operating while visibly impaired. He shows one prior that was dismissed ultimately because it complied with statute by the prosecutor after the specified probation period. This is his first drunk driving. He pled to operating while impaired. He was referred for a screening and assessment. If he had a chance to review the report with him and argument material, additions, corrections, or deletions.
No, Your Honor, it's factually accurate.
Anything you'd like to say on his behalf?
Judge, I saw the recommendations. I believe they are quite appropriate. It's my hope that he'll comply 100%, put himself in eligibility for early termination. I believe that how he's done on bond reflects how he'll do on probation. I'd ask terms and conditions be adopted. Thank you.
Sir, anything you'd like to say? Pardon?
No, sir.
You sure? I'm just asking. You don't have to say anything. You seemed reluctant. If you want to say something, you can say it. If you don't, I'm not forcing you to.
No, sir, I'm good.
You just want to get out of here, huh? Well, I don't mind telling you something here, guys. I don't necessarily, I think I've made this clear. I don't really agree with some of the new laws that have been enacted, but you know what? That's the legislature, and some of us still around here, and I don't mean in this court, but some of us in certain branches of government are going to respect the separation of powers and understand that we're not here to supplant our judgment for the legislative branch. It's unfortunate some think they can supplant their judgment for that of the judicial system, which I just don't understand, and it troubles me greatly. But see, I'm not doing that, okay, Mr. Clark?
Yes.
I'm not gonna do that, because I have way too much respect for the judicial system than to make my own rules, create my own laws, exert my power. I'm not gonna do it. So if there was ever a case where I think probation isn't warranted, and there's a presumption basically that you have to be released without probation on a drunk driving, believe it or not, if I can't state compelling reasons on the record to do so, and I can't here. You had a relatively low breathalyzer, 0.107 and 0.115. You've never had a drunk driving, you're 42, you're gainfully employed. You scored in category 1 on the alcohol and drug use portion, which tells me that you don't have a drinking problem or a drug problem, and therefore, I'm not going to place you on probation. 300 fines, 300 costs, 75 victims' rights fee, $50 justice assessment, 7 1/4. Screening fee 60 for 785. You do have to pay cost of recovery of 150 for 935. And just let me double check something here. 40 in attorney fees, 970.
I'm retained on this matter, Judge.
Oh, you are? Okay, I'm sorry. 935. 2 days community service I'm gonna give you until August. You gotta get that done a little earlier. Get it done by July 10th, and I want you to attend the Victims Impact Panel. So 16 hours community service, and attend the Victims Impact Panel. And that's it. You're gonna pay $935. We're done. If you violate, you could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, Your Honor.
Mr. Clark, you're lucky.
Thank you.
You're lucky that, I'll just let it go with that. Good luck. I wish you well. Thank you.
Judge.
Can he pay this today, by the way? It was too low, really. 935.
Your Honor, can he do,
500 now, $100 bi-weekly. I'll start that beginning June the 22nd. you're all set. If you need more time, come talk to me, okay?
All right,
I'm glad to give you an extension. You'll meet the probation, they'll explain the community service and set you up with the victim's impact. Good luck. Stephen Bailey.
Thank you, Judge.
Thanks, Stephen. Jeffrey Inch. Jeffrey David Inch, 23R5133098.
Good morning, Judge. Passing here for Karen Bath, Mr. Bath.
Mr. Inch, your name?
Jeffrey Inch.
Call in, Beth. So what are we doing here? I arraigned him, I entered a not guilty plea, he has 2 counts. How's he going to proceed?
Judge will plead guilty to count 2 and not guilty to count 1. I apologize. Guilty to count 1, not guilty to count 2.
All right, so if you plead to failure to attend your biweekly substance abuse disorder group during the week of May 4th through 10th, I'll just consider that one violation. Do you understand that?
Yes, sir.
Did you sign and read and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
My information is that this would be a 4th technical violation. Your probation could be revoked, you could be incarcerated for up to 93 days. Do you understand that?
Yes, sir.
All right, you understand all your rights?
Yes, sir.
Do you have any questions on your rights?
No, sir.
To the charge, you failed to attend your biweekly substance abuse disorder group at the Guidance Center on the week of May 4th through 10th. How do you plead?
Guilty.
Did you fail to attend your biweekly substance abuse disorder group between May the 4th and the 10th?
Yes, sir. Yep.
Anybody force you to plead guilty?
No.
I'm gonna accept that plea. Did somebody call Beth?
Beth is finishing up with the defendant at the window. She'll be ready.
Why don't you have a seat? I'm gonna have to take the other file first, okay?
Miss Foley Carter and myself would like to sign a with you
Okay,
on that.
I will do that momentarily, okay? Where is Mr. Crawford again?
Madison Gaither on behalf of Mr. Inch.
Sir?
Jeffrey Inch.
So he was going to plead, or did he plead?
He pled to
Count 1.
count 1, Judge.
So, but then I didn't want to accept the plea until I had you in here. Your name?
Elizabeth Occupation, Your Honor.
What's going on with count 1, or count 2 rather, failure to submit to twice weekly chemical testing on May 24th? I'm asking you, Ms. Wilds, do you want to?
I apologize, Your Honor. Mr. Inch appeared for testing on the 24th. His first sample was dilute. His second sample was dilute. Because he arrived so close to when they closed, he arrived at 9:20. Testing stops at 9:30. Within that span, they did allow him 2 attempts to provide a sample, so there was no time for a 3rd sample. It was a weekend. There is no PM testing, but what all sobriety court defendants are aware of, and I instructed Mr. Inch on this prior, is that if you don't show for testing in the morning or provide a sample that is testable, what Mr. Inch didn't do is he didn't go to the alternative site that evening. On Sunday, he didn't go to the alternative site a morning or evening. He did not test on Monday. He did not test on Tuesday.
All right, so unless there's going to be a plea here, I'm just going to swear her in and listen to her testimony and listen to whatever you have to say, Mr. Gay, and I'll make a ruling on count 2.
Yeah, I guess. Let's.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth so help you God.
I do, Your Honor.
Go ahead.
Would you like me to repeat, Your Honor?
Yes, please.
Mr. Inch did show for chemical testing May 24th. His first test and his second test were both dilute. Due to him arriving so close to their end time of 9:30, he arrived at 9:20 a.m. There wasn't time for Mr. Inch to stay for a 3rd sample. It is the weekend. DNA does not offer evening hours, but as instructed in the sobriety court handbook, as well as additional paperwork that Mr. Inch has received, is that if you do not provide a good testable sample, you have to arrive to the alternative site. What Mr. Inch didn't do was follow through with those instructions as well. He did not show that evening, which was a Saturday, at our alternative site. He could have went on Sunday, the next day, again, did not go to the alternative site. He could have appeared back at DNA on Monday or Tuesday, although his color of yellow was not called, colors were called and they were open, and he did not go. His color was called today. It does not appear this morning, but again, he does have an opportunity to go this evening between 5 p.m. and 7 p.m. I did not receive any communication from Mr. Inch. I was out of the office last week. Monday was a holiday, but Mr. Inch did not reach out to the probation department in regards to this issue.
Any questions of her, Mr. Gaith?
No questions, Judge.
Does your client wish to testify or remain silent?
Judge, at this point, I'm going to have him remain silent. I'd like to, with regard to what Ms. Wild said, Judge, my client, according to what he's told me this morning, did not even know that he had a violation until this morning with regard to that test. Now, he told me that he did go to the testing, and the only issue that came up was it came up dilute.
Well, dilute isn't good. They know they're not supposed to drink 14 gallons of water.
Understood, Judge. But in Mr. Inch's defense here, Mr. Inch, he's got other violations, and he's always been truthful with the court with regard to the other violations. Even when they showed up negative through the lab testing, he still admitted when he did something wrong, he admitted he took responsibility for it. Judge, at this point, I mean, I would believe that he's got no reason to deviate from what he's done.
What did I do when he admitted that he had it in the probation, the confirmation test came back negative? Do you remember, did he tell you what I did?
Well, Judge, you found him, you gave him credit for being honest with the court.
And I dismissed the show cause, right?
Correct.
So even though he admitted something that I felt like clearly established his guilt, there's no question about it, but because he was honest and because we preach honesty in the program, I felt it was inappropriate to penalize somebody who we told you have to be honest to and was honest, and the confirmation test, as it turns out, came back negative. That's why I went ahead and dismissed it. But this is kind of like, how do I say this? I don't want to get too melodramatic here, but what you've had here, it all lines up. He didn't show up, essentially, because he diluted his test. That's what he'd done. He had 2 dilute tests. He could have gone to another site. He didn't do that, even though they're told to. He could have gone to another site the next day. He didn't want to go because he diluted the sample for a reason. And then the following day, he still didn't go. And I've been watching Jeffrey here. I like the kid. I like him.
Judge, he's close to graduating. I mean,
I don't care. I don't care. I don't care. I'm finding you guilty as charged.
Oh, can I speak on this?
No, you can't speak unless you want to testify.
I want to speak on this.
Do you want to testify?
I would like to make clear that I was not fully aware that it was, I knew the first test was dilute. The second one, she said, okay, Mr. Inch, you're good. I didn't know that meant it was still dilute. I did not know. I would have gone the second day. I've done that before, prior, a year ago, when I diluted. I've been honest this whole time, like you just said.
I don't want to hear it.
I'm just telling you, if I made a mistake, I would tell you. I'm dumb. I had too much going on at home.
Why were you dilute? Let's talk about why you dilute.
I work a physically active job.
No,
trying to drink more water.
what do you tell those guys with regard to how much water they can consume?
No more than 12 ounces.
Now, it's not been 107 degrees with high humidity so far.
It's not, but I've been
So if we're going to have dilute samples every time it's 58 degrees out, and that's about what it was last week, or 60, we're going to have a big problem. You'll never have a valid test because they'll all be dilute because it's going to get hotter before it gets colder. Look, I warned you. I warned you with all of this. I warned you. You had to know you were on thin ice with me. You were doing so great, and now all of a sudden you're falling. Doesn't do any good to graduate if you're not going to keep up the program. And I mean, just stay sober. It doesn't do any good. I mean, this whole thing about completing programs, what does that have to do? It's like the guy who goes to Harvard, gets a degree, and ends up salting fries at the local fast food restaurant. I mean, it's the same concept. It does not do you any good to graduate from a sobriety court if you're still using. Now, you know what the rules are. You know what the rules are. I want you to get that lady on the phone, but I'm going to give you the benefit of the doubt in the sense that I'm getting that person on the phone on another court date here, Beth. Whoever was tending to Mr. Inch on that day, I want him on Zoom. And I'll tell you what, I'll give you the benefit of the doubt. I'll continue the hearing, but you're either going to testify or you're going to remain silent. You can't have the best of both worlds. You can't say, I'm going to remain silent and then say, wait a second, I want to talk. You want to talk? I'm going to swear you to an oath. Do you want me to swear you to an oath?
I guess I'll just remain silent, Your Honor. I would like to graduate this program.
Hang on.
No, Mr. Inch, just answer the judge's question. Either do you want to testify?
Not talking.
Well, you can't have the best of both worlds.
Judge, are you?
You don't, wait a minute. I want to make sure Mr. Inch understands this. You have the right to remain silent. There's nothing wrong with you remaining silent. But you can't remain silent and then start telling me your story and expect me to take it into consideration when you're not under oath.
Just don't know what to do. No, I want to complete this program.
I don't care.
I understand.
Jeff, I want you to listen to me. I'll give you more time to confer with your lawyer. We'll get the woman in here on Zoom. We'll continue the hearing date next week. I'll give you every opportunity to question her, have your lawyer question her as to whether or not she conveyed to you that the test was fine and you were free to go. We're gonna get her in here. When is a good day when Mr. Gates here, Lisa?
I have to check his schedule because you're off a few days next week.
It's funny because even before people violate, I kind of, and I don't mean this, I've just seen this with you, Jeff. The guy I was so proud of, and now you're just screwing around. You act like this is a option to violate probation when you feel like now. Listen.
Can we do June 9th in the afternoon? He's here at 1 p.m.
What day of the week is that?
It's a Monday.
Yeah. Is that good with you, Mr. Gaith? You're here?
Yeah, I'm here anyways, Judge.
June 9th at 1 p.m., so I want you to get them. We'll continue the hearing, okay? That's it. We'll see you next week, Jeff. And I don't know what I'm gonna do now, but I'm really disappointed in you if my mind doesn't change. Good luck.